Case 17, Northwest Inc. versus Ginsburg. We find ourselves in the Supreme Court of the United States. Facts. The plaintiff, Ginsburg, created headaches for the airline under its frequent flyer program, and they kicked him out of it. He then brought a class action alleging that Northwest Airlines had ended his membership as a cost-cutting measure tied to its merger with Delta Airlines. He asserted 4 separate claims. Number 1, Northwest had breached its contract by revoking his Platinum Elite status without valid cause. 2, Northwest violated the duty of good faith and fair dealing because it terminated his membership in a way that contravened his reasonable expectations with respect to the way Northwest would exercise its discretion. 3, negligent misrepresentation. And 4, intentional misrepresentation. He sought damages in excess of $5 million as well as injunctive relief requiring Northwest to restore the class members' World Perks status and prohibiting Northwest from future revocations of membership. The District Court held that the claims for breach of the covenant of good faith and fair dealing, negligent misrepresentation, and intentional misrepresentation were preempted by the Airline Deregulation Act of 1978. Because they were related to Northwest's rates and services and thus fell within the ADA's express preemption clause. Ginsburg's remaining claim for breach of contract was dismissed without prejudice for failure to identify any material breach where the frequent flyer agreement gave Northwest sole discretion to determine whether a participant had abused the program. So, Ginsburg appealed the dismissal of his breach of the duty of good faith and fair dealing claim. The Ninth Circuit reversed. Relying on pre-Wolin Circuit precedent, the Ninth Circuit first held that a breach of implied covenant claim is too tenuously connected to airline regulation to trigger preemption under the ADA. Such a claim, the Ninth Circuit wrote, does not interfere with the Act's deregulatory mandate and does not force the airlines to adopt or change their prices, routes, or services, the prerequisite for preemption. In addition, the court held that the covenant of good faith and fair dealing does not fall within the terms of the Act's preemption provision because it does not have a direct effect on either prices or services. The issue: whether the ADA preempts a state law claim for breach of the implied covenant of good faith and fair dealing if it seeks to enlarge the contractual obligations that the party voluntarily adopts. The holding: a unanimous Supreme Court reversed and remanded. The ADA does preempt a state law claim for breach of the implied covenant of good faith and fair dealing if it seeks to enlarge the contractual obligations that the parties voluntarily adopt. Here's some of the reasoning. In contract law, the implied covenant of good faith and fair dealing is a general presumption that the parties to a contract will deal with each other honestly, fairly, and in good faith, so as to not destroy the rights of the other party or parties to receive the benefits of the contract. It is implied in several contract types in order to reinforce the express covenants or promises of the contract. When a court or trier of fact interprets a contract, there is always an implied covenant of good faith and fair dealing in every written agreement. Here, the plaintiff Ginsburg alleged that Northwest had breached its contract by revoking his Platinum Elite status without valid cause. Second, the complaint claimed that Northwest violated the duty of good faith and fair dealing because it terminated his membership in a way that contravened his reasonable expectations with respect to the way Northwest would exercise its discretion. The Act preempts a state law claim for breach of the implied covenant of good faith and fair dealing if it seeks to enlarge contractual obligations that the parties voluntarily adopted. The Act prohibits states from enacting or enforcing a law, regulation, or other provision having the force and effect of law related to an air carrier's price, route, or service. The phrase other provision having the force and effect of law includes state common law rules like the claimed implied covenant. Accepting common law claims would disserve the Act's central purpose, to eliminate federal regulation of rates, routes, and services so they could be set by market forces. Northwest's program connects to rates by awarding credits redeemable for tickets and upgrades, thus eliminating or reducing ticket prices. It also connects to services, that is, access to flights and higher service categories. Because the implied covenant claim sought to enlarge contractual agreements, it is preempted. Under controlling Minnesota law, parties may not contract out of the implied covenant. When state law does not authorize parties to free themselves from the covenant, a breach of covenant claim is preempted. Participants in frequent flyer programs can protect themselves by avoiding airlines with poor reputations and enrolling in more favorable rival programs. The DOT has authority to investigate complaints about frequent flyer programs. The court also noted that the plaintiff did not appeal his breach of contract claim. The court reasoned that Ginsburg's claim of ill treatment by Northwest might have been vindicated if he had pursued his breach of contract claim after its dismissal by the district court. He argued that contrary to the holding of the district court, the frequent flyer agreement did not actually give Northwest unfettered discretion to terminate his membership in the program. And the United States makes a related argument, namely, that even if the agreement gave Northwest complete discretion with respect to a determination regarding abuse of the program, the agreement did not necessarily bar a claim asserting that membership was ended for an ulterior reason, such as an effort to cut costs. If Ginsburg had appealed the dismissal of his breach of contract claim, he could have presented these arguments to the Court of Appeals, but he chose not to press that claim. He voluntarily dismissed the breach of contract claim and instead appealed only the breach of implied covenant claim, which the court held to be preempted.